Good evening, members. Unfortunately, this evening the chair is unwell and the vice chair is on maternity leave. So therefore, our first order of business is to nominate a chair for this evening's meetings. So could I please have nominations from you? Is that seconded? Okay. Right, we've got no more nominations. Okay, Councillor Burgess, could we please vote for Councillor Burgess? Right, and against? No. Okay. Okay. Councillor Keating? No, Councillor 1, 2, 3, 4, 5 as well. So 5 and 5. Okay. I was hoping this wouldn't happen, members, but obviously it has. Is there any advance on any further votes for Councillor Mrs. Burgess? No? Any more votes for Councillor Keating? Okay, members, can I propose then that I've checked this with our legal colleagues, and the normal procedure for this is to spin a coin. Councillor Keating, I have a coin. Councillor Keating, are you happy for ladies to choose head or tails? Thank you very much. Councillor, it is still 50-50. Councillor Mrs. Burgess, heads or tails? Okay. I'm going to make sure that I can't do this, so I'm just going to flick it. It's heads. Councillor Mrs. Burgess, you're the chair for the evening. Thank you.
Call for nominations for the Vice Chairman. Any further nominations? Oh yeah, is Councillor Sherlock seconded? Thank you. Right, so votes for Councillor Sherlock. And for Councillor Keating. Councillor Keating. Come and hold my hand, Sean.
Yeah. So just running through normal business and
Will do.
Resignations and replacements.
Right, thank you. Thank you. Yeah.
He's here by then.
He's not here yet.
He's not
When
here
is he
yet.
coming?
Yeah.
Right. I'll just invite them to speak when they want to, right? Thank you. Right, we'll get down to the usual boring bits, the fire evacuation procedures. There are no... if the fire alarm goes, please exit from the back, go down the stairs and out into the park and meet up by the aviary. And please note this meeting is being webcast. Apologies for absence. Virtually everybody, I think, on the Conservative side.
I wonder why.
We have apologies from Councillor Leeds, obviously. And we've got resignations and replacements. Shall I do the Conservative ones first, or?
Anybody.
Yeah. For Councillor Nisbeen, Councillor Sherlock. Councillor Gardner is being replaced by Councillor Mrs. Tucker. Councillor Mrs. Still is being replaced by Councillor Gerderson. Councillor Miss Jarrett is being replaced by Mrs. Diane Taylor. And Councillor Mrs. Frankham He's been replaced by Councillor Potter. Are there any others? No. Thank you. Right, declarations of conflict of interest or whipping decisions. There are none. Urgent items, there are none.
Sorry. Could I just ask for your guidance on this? Sorry, do you need to? I have a revised recommendation to make at some time relating to the report that we have before us this evening on Manidown. I've got hard copies for all of the committee present. It's just a question of when I deal with that. I'm happy to circulate that now with your instruction for people to have a chance to look at, or to do it when we actually get to the report and the recommendation that's contained within it. So I seek your guidance on that, Chair.
Thank you, Councillor Potter. Could you keep your powder dry until the appropriate time, please, in the meeting?
When will that be, Chair?
When we're drawing to a conclusion. Thank you.
Whenever that may be as well, Chair. Thank you.
Please note that the minutes of the meeting held on the 10th of September will be confirmed at the committee meeting held on the 8th of October next. Item 8, member and public participation upon this is contained within the agenda. I know Councillor Donnell wanted to speak on this, but it doesn't seem to have got here yet. So perhaps we can slip him in when he does arrive, with your indulgence. Standing invitation to relevant portfolio holders to present reports of activity, etc., and or bring forward policy development issues. When did you wish to speak, Councillor, is it? Please do.
Good evening, committee. I speak as the portfolio holder, the cabinet member responsible for Manidown. So I'm here representing the landowner and not the local planning authority. As joint landowner with Hampshire County Council, we have a clear legal requirement to actively promote the land for development, consistent with the legislation originally used to buy the land, the Town and Country Planning Act 1990, and the decision of full council in July 2012 to proceed with the proper plan development of Manidown. The NPPF also requires us as owners to cooperate constructively with the local planning authority during the preparation of the local plan, and that's what we're seeking to do here. I hope tonight that we will provide understanding and illumination of a very significant and inevitably complicated project to build new homes and supporting amenities for the people of the borough, which will bring lasting change and, I hope, benefits, and in the process clear up some of the important and understandable areas of concern for residents and their representatives. Necessary to ensure that the various policies in the draft local plan, including site policy for Manidown and allocation boundary, are sound and capable of enabling the progression of a planning application that is deliverable and viable once the local plan is adopted. You won't need me to remind you that this is vital given the extent to which the housing proposed at Manidown is going to contribute hugely to the needs of our residents for homes up to 2029. As landowner, we consider the draft local plan in respect of Manidown to be positive. Our representations are intended to clarify and shape the draft policy wording to help the LPA achieve an adopted local plan, of which Manidown forms such a major part.
Thank you, Councillor. Referrals from other committees. Oh yes. Could you remain in your seat in case anybody has a question? Please.
Thank you. Hi. I wanted to ask one question of substance. Really, is the reason we bought the land and the rules and the legislation appropriate, etc. Is not necessarily consistent with the decision of the full council on the 25th of July. And have you got anything to say about that?
I'm sorry, Councillor Keating, what isn't consistent?
Well, we bought the whole of Manidown and acquired it under legislation which the High Court judge told us we had to develop, because that's the rules that we applied at the time. But the decision of the full council on the 25th of July 2013 did not comply with the judge's decision, because it excluded much of the Manidown land from development.
I'm not in a position to give you an answer, which is if what you're inviting me to do is to say that full council was incorrect in its decision in July 2012, and I can't do that.
But what approach are you going to adopt then? Which of the wrong decisions are you going to endorse?
I do not accept that a wrong decision was made then. It's for you to make that case, but as far as I'm concerned, the full council made its decision. It was a correct decision.
Councillor Parker.
Thank you, Chair. Good evening. I'm referring to the document URS. And I have to say that in the way that presented by the paper, I'm not sure of the date timeline. So I'm asking this question purely from the comment that's made by the consultants on page 23 of 35, which actually reads, secondly, So I'm referring to the right-hand side. There's towards the bottom, the paragraph starts secondly. The western boundary of the Manydown allocation has been erroneously amended to remove significant portions of parcels 4 and 5. And we have reference to that as seen in figures 1 and figures 2 on the following page 24. And so my question to you as portfolio holder is that in the light of that comment and the comments following on below the maps, would you agree that that actually renders the decisions made by Cabinet and subsequent decisions made by full council unsound?
And that's not my interpretation of things, and I think that what we can look for tonight to help is in giving information on that sort of question.
Well, the basis of my suggestion is that the full council were given incorrect information, against which then a decision was made. It's clearly stated by the consultants. They make reference in considerable technical detail. I think it's a quite straightforward interpretation to take.
This is a statement made by consultants, and it will have to be looked at. And I can't give you an answer to that now.
Councillor Potter.
Councillor Isaac, I mean, I'm sure you'd agree with me. It's a pleasant change to have consultants URS and Beyond Green, who seem to be displaying some integrity on this matter. I noted from their report, very critical of this council's policy in respect of Manidow, and they use words such as unviable, unreasonable, inconsistent, not justified, in the context of our position vis-à-vis the local plan, which you must presumably find disconcerting. And I also just wanted to check with you, are you aware of the report, I believe it's in the name of the Executive Member for Policy and Resources of the Hampshire County Council, which is going to be considered next week on the 24th of September, which makes damning criticism of the Borough Council's submissions in respect to the local plan. Has this been brought to your attention?
To answer the second point first, no, I'm not aware of it, so I can't offer you any comment on that. Well, I was going to answer the first point. and the first point is, I'm sitting here today representing the landowner. We are making representations. We do have concerns about aspects of the policy for Manidown, and hence we are proposing to make those representations in due time for the consultation period till October the 4th.
I mean, with your indulgence, I will quote direct from the County Council report in one aspect where the words used are, the implications for Manidown are more significant in that the extent of the proposed site allocation boundary is not sufficient to deliver the required housing numbers, and the late introduction of the Western Bypass Reservation would potentially render the development unviable. These are fundamental criticisms, obviously, of the position we've adopted, which, in my view, and I don't know whether you'd agree with this, is leading this council inexorably towards a further legal challenge, which is quite unbelievable.
Councillor Potter, it's not a document I've seen. I think it's impossible for me to respond in any way to this. We have papers in front of us, reports in front of us, and I'm quite happy and indeed it's necessary for me to be here to hear what you have to say in respect to those. But I'm not going to. It's not appropriate. It's not proper. I haven't got the full report in front of me. I haven't seen it. I wasn't even aware of its existence. And it's another public body, albeit their partners were the St Manidown. I don't know the status of the report. I could go on, but I cannot respond to it. And you're not going to help the quality of the debate this evening by referring to some document that apart from perhaps you and your colleagues, nobody else here is any the wiser of.
One final point then on this matter, if I may. I mean, this is a publicly available document. It's in the name of the Executive Member for Policy and Resources at Hampshire County, a Cabinet colleague. I thought we were meant to be working in partnership with Hampshire County. So did you, obviously, which is a striking indictment, I think, of the way we are working with Hampshire County. I can't say much more than that if you haven't seen the document. I'll refer to it later on, Chairman, within anything that we have in the way of debate. Thank you.
Thank you, Councillor Potter. Number 10 is referrals from other committees of the Council. None. Issues referred by Cabinet. None. Members out representations to the local plan. report from Richard Bailey. Would you like to present your report?
Thank you, Chair. Hopefully everyone can see the presentation on the screen. If not, we'll pause and hand any appropriate handouts out. So what I'm going to do is just provide an update which provides some context and some information in relation to the report that you have in front of you to consider tonight. So as a reminder of the current position, as Councillor Isaac said, July 12, Council passed a resolution to actively promote Manydown, and that is the policy within which the landowning part of Basingstoke and Dean Borough Council is operating, or have been operating since July 12. Piece of work that was done before March 2013 was a site assessment report by Tibbalds and some transport assessments by JNP. Both of those confirmed that there was a capability of housing 3,000 homes on Manydown within the local plan period. During the course of the period of time since or before March 13, there were 2 letters sent. First of all, back end of October into November last year, a letter sent to the local plan authority at Basingstoke and Dean to ask for up to 4,000 homes plus an option of 400 on plot 7 to be included in the local plan. And then more recently 2 letters have been sent to the local planning authority. First letter referred to the site boundary and refers to the site boundary in the context of the recommended site boundary, which we'll show in a minute, and pointing out that in order to deliver 3,000 units, then the recommended site boundary, which we'll show in a minute, needed to be adopted. And the second letter referred to the exclusion of Manydown from the Oakley Neighbourhood Plan boundary, which we refer to in the report. Over the last few months, there have been some work on visioning by Beyond Green and master planning by URS, and there's also been engagement with the MAP at 2 workshops and 1 site visit to Manydown, together with meetings with the trustees and Worting landowners. So we're fulfilling our obligations as landowner in terms of the way we engage with the relevant people. During the course of August, you will see that or you have seen that the pre-submission local plan's been issued for consultation. It has in it a site allocation for Manydown of 3,080 homes, which is a sizable amount of the new homes that need to be delivered in the local plan period from new sites. As you've seen in the report, the landowner side of Basingstoke and Dean believe that the site boundary and the policy related to Manydown, together with 1 or 2 other details in the local plan that's out for consultation, need to be redrafted to help achieve the local planning authority's aim of a deliverable and sound local plan. And that's really what the report is about, how we help through our written submissions to get the local plan to a point where Manydown can deliver approximately 3,000 homes in the local plan period in a deliverable and viable manner, so that the local plan is sound. So, as Councillor Isaac said, our perspective as landowners here is to ensure the proper planning of the area due to the nature of the way the land was purchased, to actively promote the land as per the council resolution, and in that discharging that responsibility, we have that shared responsibility with Hampshire County Council, all enshrined through the judgments last year through the JR. In that context, the landowner, in order to help the local planning authority have a local plan that's deliverable, viable and sound, our points of principle, or our starting context for our comments and our representations, are whether there are issues to do with the test of soundness under the NPPF, that's the National Planning Policy Framework, and you'll see both in the report and the appendix from URS, we've obviously assessed the local plan under that context. There's also some issues around the overall plan in relation to the level of detail that's in the Many Down policy, which we've highlighted in the report, and also the interrelationship with policies. In particular, I'll draw your attention to the policy in Appendix 5 in the local plan, which sets out, in our view, a comprehensive and proper master planning process that would involve the community and involve the local planning authority after the local plan has been adopted and before any planning application has been put in place. And so there's a level of detail in the policy at the moment that we would expect as landowners to be talking to the communities pre the submission of a planning application, but importantly after the actual local plan has been adopted. And you will see there are comments where we believe that that level of detail isn't appropriate now and is better explored with the community at that stage post the adoption of the local plan. In terms of our overall response, what I'm just going to do is probably in the time available pick up one or two principal issues. I'm not going to go through all the detail that's in the paper or indeed in the URS technical appendix. So I'm just going to pick up probably the main issues in order for the committee to understand, I think, the principal points that we're seeking to put across. So that doesn't mean that anything that's not in the paper we would not be planning to submit. It just means that we're just highlighting particular issues for your consideration. And the main ones are the land boundary, which we'll come to next, the site policy, and then finally some other policies which I was referring to earlier in the pre-submission copy of the local plan. So I'm just going to take through the land boundary as it currently appears in the pre-submission local plan compared to the land boundary that you'll have seen in the appendix that was being referred to by, is it Councillor Parker earlier? And that is the original recommended site boundary that we submitted written representations to the Planning Authority in May and June of this year. So that's the boundary we were seeking to be included into the local plan when we wrote to the local planning authority in May and June of this year. I'm now just going to explain something that's quite important to the submission that we're making, particularly around deliverability and viability. We have in the local plan period a matter of at best 12 years, at worst 10 years to be able to deliver 3,000 or so houses. And that, the important ingredients to be able to deliver that amount of houses in that amount of time are space and the ability to produce houses per annum at a rate that would deliver 3,000 houses. In other words, the productivity of production per annum is as important as the amount of space that's been allocated in that plan boundary. And the key point that I'm going to go through in the next couple of minutes is the ability for us as a landowner, in order to deliver that productivity rate of that's necessary per annum to deliver 3,000 houses in the plan period, requires the ability of a number of development outlets or plots to be actually being produced at the same time. You would not be able to produce 3,000 houses in a 10 or 12 year period just operating on 1 or 2 plots per annum. You would have to have, and I'll go through the numbers in a minute, a significant number of plots on the go in any 1 year in order to produce 3,000 houses within the planned period, i.e. within a period of 10 to 12 years. So the issue isn't just about space being allocated, the issue is about the ability to get a number of these plots on the go at any one time. And the important part of that ability to get a number of plots on the go at any one time is the ability of a road or roads accessing the site. So if you have one road accessing the site into a cul-de-sac, then there are going to be less number of plots capable of being delivered at any one time than if you have 2, 3 or 4 roads accessing the site. And that's the important issue that we're going to touch on now in terms of the ability of Manydown to be able to deliver the amount of houses in the time period that's stated in the local plan. So in this pre-submission local plan, which is the plan that you see in the local plan for consultation, the boundary, as you can see to the west, is fairly on a fairly north-south trajectory. In the recommended site boundary, the boundary is further west. Doesn't come out terribly well, does it? Yeah. Did you actually give copies of? Sorry, did you give copies of that? No, I don't think you have. Right. I think just for the ease of presentation, if we could just hand some of these out, it's not as clear as I'd like it to be. Yeah. Now you can sense the colours, I think, up there, but maybe not quite the actual definition. So, I'm going to highlight here, I'm not going to come up and just point, but actually you can look at your plan. What I'm going to highlight here is just on that western boundary, this red line, the inner red line, is the boundary that's in the pre-submission local plan. The dotted red line on the outer line is the original recommended boundary. So that dotted line to the west is the original recommended boundary. The blue line, the blue areas relate to the areas that are within the local plan submission boundary, and then the kind of salmony colours relate to the additional areas in the recommended boundary. The yellow areas at the top and the bottom are all part of the Manydown boundary in any event, in any scenario. And the green areas, and this is quite important, are areas that are not within the allocation or ownership of Hampshire County Council of Basingstoke and Dean. There are 3 landowners at Worthing, and the trustees have some land as well in that area. This is the railway line, and this sort of white line here is Worthing Road. And the key issue that I'm going to draw your attention to is the ability for us as landowners to be able to put a junction here on Worthing Road that would then have a road accessing into the plots down here and a road accessing the plots up to the northeast. And as currently drafted with this particular boundary, we don't have enough space between this boundary and the end of our land ownership to be able to put a junction that would form a development link road to the north and to the south to enable plots to be developed here and up here. And that is a crucial element of why the boundary, we believe the boundary should be taken back to this dotted line, which is what we submitted in May and June to the officers. If I then take you back, give you some indication of what that means in quantum. Particular plan, which is in the local plan, if we were to be able to develop in the yellow areas and sensitively in the red crosshatch areas that we own in our land ownership, so that includes all the yellow areas and the red crosshatch areas that's in our land ownership, we would only be able to get, on average, 7 development outlets per annum, and that would give us a figure of around 2,000 houses in the local plan period. In other words, we would not have, because of that road issue that I've referred to, we would not have the ability to be able to access the plots to the west of the boundary which we estimate would give us another 4 or 5 plots on the go to get to 11 at a peak production timescale, and then at 11 at a peak production timescale would give us 3,000. And that is the critical issue around the boundary. It relates not just to space, it relates to the accessing of that space from at least three different points from the north and from the Worthing Road to the north and to the south, to be able to access a number of plots and produce, have a number of plots on the go. We think 11 at the peak period, in order to be able to accumulate 3,000 houses in the plan period. And that pretty much covers the first bullet point I've identified. That in relation to the policy is covered in policy G, which you'll note that policy G refers to the land boundary and additional constraints. And those additional constraints refer to landscaping and heritage. And we believe that with the recommended boundary further to the west, that we could develop sensitively within those constraints, as we've outlined in the reports, the various reports that have been submitted. We move on to the dual carriageway, which relates to clauses N and O in particular. In a wider context, the local plan has to have some evidence base in order for it to be sound in front of the inspector. We obviously don't have any evidence for a dual carriageway in the local plan, and we know that as part of the local plan development, part of the development of Manydown, that we don't need a dual carriageway to facilitate 3,000 houses. The JMP transport report looked at a development link road single carriageway with junctions off the Worthing Road and off the A339. And therefore, there isn't any evidence or information that would support the use of the word dual carriageway to be safeguarded. So the clauses in N and O where the words dual carriageway are used, we believe need to be deleted. All of those matters that I've just gone through have pretty serious implications on the Manydown project being able to deliver, being viable, and produce the right yield in terms of numbers of houses at a rate per annum within the planned period. And they also have implications around the character and development form of Manydown in the way that it gets developed as a sustainable community. Clearly a dual carriageway would sever the community and would take land take up beyond what the figures I've quoted. The figures I quoted earlier don't include any additional loss due to safeguarding for dual carriageway. So those figures would come down if we had to put a dual carriageway through Manydown. They'd come down a couple of hundred at least. So that's the kernel of the issue around our ability as landowners to develop 3,000 houses within the planned period. Other particular site policy issues that we've highlighted in the report, and again these aren't meant to be exhaustive, drawing your attention to the fact that the Gypsies and Travellers clause in B needs to evidence some need beyond 2017 when Manydown would come on, and I think that combined with the local shopping facilities where we'd want to explore with the local planning authority in the context of the overall borough what the overall need would be, those two particular elements are better suited in the master planning process. Secondary school point, it needs to be clarified around when a secondary school is required, and that only the landowner's responsibility for a secondary school is to provide the land and contributions, a proportion of contributions. It is not to pay for the secondary school, so there's clarification needed on that. And clearly within the first phase, i.e. 3,000 houses of Manydown within the local plan period, the requirement for a secondary school isn't necessarily triggered. In other words, 3,000 houses won't trigger the need for additional secondary school. That assessment's been done by the Education Authority. There's green space infrastructure points where We have an overall green space strategy we're developing at the moment, and we'd obviously need and want to discuss that at the master planning stage with the local authority. But the particular point about Manydown incorporating local deficits elsewhere is not appropriate. Country Park, our requirement is to provide the land and contributions to the country park, but that is part of an overall green space or green space and infrastructure strategy. The Heritage Clause I is probably more appropriate for the Worting landowners to respond to, because that's where the heritage issues largely fall. And the clauses J and P, in relation to existing residents on the surrounding areas of Manydown, we believe as landowners that the appropriate policy objective would be to protect where possible and enhance where possible the quality of life for those residents. And we believe that the best place for that, or the best process for that, would be through the master planning process in consultation with the communities, because at that point we can actually consult with the communities and work out what would be appropriate in terms of achieving that policy objective. And so there's a number of pieces of detail in J and P that we believe are better explored pre the application position and during the process that we go through with the local community and the local planning authority in the master planning process. In other words, the local planning authority would be involved in that master planning process as well as the local community. So moving on to sort of wider policy implications, you'll see in the paper that we believe on affordable housing we'd need to give further consideration to this once the Three Dragons report is available. And again, we can discuss that during the master planning process with the local planning authority. The Oakley neighbourhood plan, we've already sent a letter in back in May to the planners at Basingstoke to essentially say that Manydown should be excluded from the Oakley neighbourhood plan boundary because it has wider strategic implications that can't be dealt with through the plan. Strategic gap, we're seeking to make sure the policy enables us to safeguard any particular policy, Manydown policies on safeguarding, particularly to the south of the Worting Road and through over the railway line into the southern side of the site, so that if we needed to safeguard it for future crossings of the railway line, we're able to actually put in place that form of safeguarding. And on employment, as I've already mentioned, we believe that Manydown would offer an opportunity for a retail offer that's commensurate with the town-wide offer in an overall borough-wide assessment of that retail offer when the local planning authority get to that point. So just wrapping up in terms of next steps, today is where we are, and that really is the remit of EPP OSCOM. We're looking for, in terms of recommendations, the notes on the progress and a review together with comments from the committee tonight. We have next Tuesday night the Manydown Executive, which would consider the views of the EPP tonight, and then, as it states in the paper, delegate authority to submit representations to local plan by the 4th of October, and importantly also to enable memorandums of understanding, MOUs, is memorandums of understanding, to be developed between ourselves as landowners and Worting landowners, and ourselves as landowners and the Manydown Development Company, who represent the trustees on the Scraps Hill site. That's MDC's, the Manydown Development Company. And those are going to be important in terms of how we progress the overall Manydown development, as I think we were highlighting in the map that I've handed out. And then we have a deadline of submissions of 4 o'clock on the 4th of October to the local plan authority at Basingstoke, and we'd hope to be able to do that jointly with Hampshire.
Thank you very much. I'm going to invite questions for the officer, but can I point out we have a confidential paper? If anybody needs to touch on that, would you please let me know in advance so that we can take the appropriate action? Thank you. Councillor Keating.
Thank you, Chair. Thank you for that presentation. Very clear. One of the issues that I wanted to ask about is you didn't touch on the Roman Road and Winkleberry, but the Cabinet on the 22nd of July and the full Council on the 25th of July this year had before them representations to create the equivalent of gap between the Manidown side of Roman Road being developed and the existing community in Winkleberry. The councils prior to the 22nd of July, their position was to integrate, and it would appear from the 25th of July council decision, the intention would be to not integrate in a constructive way. Would you have any wish to comment on that?
From a landowning perspective, an officer perspective, we recognise the difficulties in large development or undertaking large development in nearby communities, whether that's Winkleberry or Kempshott or Oakley or wherever it might be. In and around Manydown, we recognise the sensitivities and the difficulties surrounding that. What we'd like to do is to explore the issues that have been highlighted through the master planning process and through consultation with the communities, so that in the context of proper planning, which is identified in the URS report, we can come to solutions that benefit both existing residents and new residents and enable proper flows and proper quality of life. So we weren't highlighting the detail in those particular clauses, but we are, and those two clauses I highlighted earlier, we are wanting to have as our policy objective, how do we create, or maintain and enhance, if possible, quality of life for nearby residents through the way we work with them in the master planning process to design a community that can facilitate that, both at Manydown and the neighbouring communities. So that's our position, and that's the process we would like to adopt further down the line.
There are currently constraints as a result of the 25th of July Council decision in terms of how that is developed, how that particular part of the plan, overall plan, is developed. Is there a need to make representations or alterations before the 4th of October in order to reduce those or remove those restrictions?
I think the way I would view it is that there's a need to redraft along the line of the policy objective of quality of life, and really focusing on that so that it gives all of us, including the local community, some flexibility further down the line when we undertake the master planning.
Thank you.
Yeah, Councillor Potter.
Good evening, Richard. I mean, I know these situations are difficult. I'm not trying to draw you into political observation, but it's a real political subject. But, I mean, would you agree with me, following the intro that you've given us in respect to the revised boundary and obviously the allocation of land for the dual carriageway, that quite frankly the comments and representations that as landowners we've made thus far in respect to the pre-submission local plan does have to be revisited? It cannot be appropriate to the proper development of Manydown, which this council ostensibly has a policy on. Would you agree with that?
Sorry, Councillor Potter, can I just clarify which comments you're referring to?
In respect of the council when it approved the draft local plan, incorporating obviously what was said about Manydown on that evening, where the revised boundary and reference to the western bypass was included within that draft local plan at that time. It subsequently suggests, I think, to all of us that those are observations are requirements that cannot be met if we want to see the effective and proper development of Manidown.
I think I'll just draw your attention to what I said at the beginning, and we have a responsibility as a landowner to help the planning authority get a local plan that's sound, deliverable and viable, and that's really the objective we've been following in terms of constructing these written representations that you have before you in the paper.
I mean, I guess this will be a difficult question as well, really, but it relates to our joint partnership working with the County Council, I think, really. And I mean, I put Councillor Isa on the spot in regard to the report that I've quoted from, which is, as I say, public knowledge and is going to the County Council on the 24th. I mean, are you aware of that report and the critical nature of that report, which is being considered by our partners in this?
I was made aware of it tonight. And yes, I'm aware of the critical nature. What's contained in the paragraphs that I read tonight, and I only read the paragraphs about Manidown just before the meeting started, are consistent with our position that we've outlined in the paper tonight and what I've communicated.
Councillor Parker.
Thank you, Chair. Good evening. I have quite a lot of questions, Chair, so I'll be very pleased to give way to other members that have studied the papers subsequent if I get to start to bore people. But I'd like to first of all refer to the report on page 12 of 35 under clause G, and just make quick reference to the under the heading officer comment, and then we have on the right hand side of that suggested changes references made to the policy restrictions seriously compromise the ability of a district centre, further wording, and also there is no definition provided for the term additional criteria. But I can't see under suggested changes any reference to those 2 points unless it means that that's supported.
First of all, just a bit of context. The junction I was pointing out on the map that we've handed out at Worting Road is where we would site the district centre, and that's ordinarily where you would put a centre of gravity for a development of this size, and so that's just to give you a bit of context. In answer to your questions, the comments that are in the middle box around the district centre and additional criteria refer to the existing or the boundary that's in the pre-submission draft and the wording of the Manidown policy in the pre-submission draft. What we've then said in terms of recommendations on the column to the right is we would recommend the site policy boundary to be moved further west, as I've indicated tonight. If that was to be the case, then we could site the junction that I was explaining on the map we've handed out, and therefore we could appropriately locate a district centre at the fullness of time in that place. In relation to your point about additional criteria, the second sentence on the right-hand side, where it says redraft clause G to identify the need for sensitive treatment of the western edges of the development in relation to landscaping and Worting land in relation to the heritage policy, is our suggested change in wording, or would be our suggested change in wording, instead of the use of the words additional criteria.
That leads me on then to Appendix A, which is, I have it showing as A3. It's the policy SS3.10 Manidown Basingstoke. It's that colour, it's at the back of the papers. Yes, 44154, sorry. Which appears to be the sort of, unless I'm completely getting it wrong, the main sort of, most of it. And what I want to just ask, I think, because obviously I want to talk about it in debate, Chair, is that to ask the officer that my summary of the comments in the report related to the URS the URS document shows me that of 20 I'm not sure this appendix as we have it here, whether it's historic, current or proposed. I think it can't be proposed because I think some of the wording in the report is going to change this particular policy. But of 21 clauses, there are 6 that are redrafted, 9 to be deleted. There's 3 that are showing change and amend as best as I can establish, and there's 1 that I'm really not sure what the officers are actually saying, and there's 2 where there's no change. So I want to just actually then ask that, are we being asked this evening to accept this policy wording with 6 redrafts that are yet to be provided at some subsequent date?
And what you're being asked is this particular policy, SS 3.10, is the policy that is out for consultation in the pre-submission draft of or pre-submission of the local plan. That is the policy we're responding to in the representations, and you're being asked to consider in the table that you're referring to, particularly the right-hand column of the table, the summary of how we would propose that policy to be redrafted or amended, and that's what you've been asked to consider.
There's another councillor. You said you'd be prepared to. Thank you, Councillor Mrs. Taylor.
Thank you, Chair. I'm assuming we're really just responding to some of the comments that Mr. Bailey has made, but there's obviously quite a lot in the actual report that we need to talk about as well. But I'll just confine myself to things that you've actually said in your report at the moment. We'll just say one thing. I'm assuming that you're recommending that in this planned period, the development in Manydown will be north of the railway line, and you're suggesting that 6 is excluded at this time from the plan. Is that correct?
If we were able to have the policy bounded amended back to the recommended boundary, and we were able to take account of the majority of the changes, particularly the significant changes that I drew attention to tonight, that relate to the deliverability and viability, then we believe that north of the railway line that we're able to deliver 3,000 houses with around about 11 development outlets at peak period prior or in the local plan period to 2029, in which case, if that's possible in planning terms, as it would be possible in development terms, then site 6A we have offered it, as you see in the report, up as a reserve site for the council to consider. That would still, if the council wanted us to, require us to think about how 6A would then be developed at some point in that period of time. If they believed, if the council or planners believed that site 6A, in addition to the 3,000 north of the railway line, was required for an overall borough plan housing to meet the overall borough plan housing target. So there would have to be that consideration in that context.
So you're not? Are you saying that it's unsound, or you're just saying you don't need it at the moment?
We're saying that if the policy boundary was amended along the lines that I've described and we've described in the report, and the policy changes were made that we've highlighted, then Site 6A isn't necessarily required in the first phase of the local plan to be able to meet the housing target allocated for Manydown, unless the planners decide that in the overall borough target they need some more houses, in which case we're prepared to look at Site 6A in that context.
Thank you. You may not know this because you wouldn't know it from the report, but in this committee this time last year, when we first looked at offering land for development, we pretty unanimously recommended just north of the railway line to be considered for development because it is the most accessible and the most viable. And several of us spoke on that. And it seems to have sort of slipped off the map a little bit, but that is precisely what we recommended. And whilst I'm obviously therefore very happy, because I think this is unviable, this site, for it to just be north of the railway line, I'm certainly not happy if it stays as a reserve site, because obviously we could be peppered with houses that we don't want across Manydown. So that would be my opinion. Now, just on what you have said, you said you're talking about fitting in a junction on the Worting Road, and you said that the reason you need the extra land to the west is that you can't fit a junction in. Why would you need quite so much land just to fit a junction in? And is there no possibility at all of buying some land off the area outside of our ownership in order to fit in a junction?
The context that we have in terms of putting together our written representations are that we have to put together our written representations on the basis of the land that we have in our ownership. And therefore that, given the timescale between now and the 4th of October, is what we've been focusing on. In terms of the ability of siting the junction, I think if you look at the map, the ability to put it in the between the solid red line and the land that's outside of our land ownership, there's not enough space in terms of the size of the junction, but more importantly in terms of the sight line clearances that would be required for that type of junction. So technically we wouldn't be able to do it in that space available in the current proposal under the local plan proposals.
I appreciate that, but the recommended site boundary to the west now is right up to the road that leads to Wootton St Lawrence. So that's a huge stretch. Do you need all that just to fit in a junction, is what I'm asking?
No, we don't need all that. It just wouldn't be possible in the space that we've currently been. It wouldn't be possible in the space that we've been allocated, technically, but we wouldn't need all of the boundary. We wouldn't need to go to the boundary, the dotted red boundary, if that answers your question. And in fact, sorry, just to help with that, the reason we wouldn't be going to the dotted red boundary is because around that junction would be a district centre that would emerge over time. So clearly we would want to develop sensitively, and therefore we wouldn't be putting that level of development on the edge of that dotted boundary.
Thank you. And the only other thing, if I may, just one more, from what you said, although there's several other things actually on the report, is you talking about the Oakley neighbourhood plan. You're saying that you'd like Manydown land to be excluded from that because of wider strategic implications. Now, obviously, Oakley Parish Council and the villages of Oakley have got in quite quickly with the neighbourhood plan because they're taking seriously the need to actually build extra houses around Oakley. And they have been granted their parish land, which is the usual, I assume, the parish of Oakley is the land that they've been given. And in any parish, you've got all sorts of different ownerships on that land. So why exactly does the Manydown land require to be excluded from that? Why is this a special case?
In planning law, under the NPPF, the National Planning Policy Framework, neighbourhood plans have to conform with local plans. And therefore, there's a strategic level. At a strategic level, the neighbourhood plan is effectively takes its guidance from, its direction from the local plan. Manydown is a strategic project in the local plan, and therefore the neighbourhood plan boundary in particular needs to take, and thereafter the policies need to take account of that strategic objective, the delivery of Manydown.
Sorry, if I could just have one last thing. I mean, I do understand that obviously the neighbourhood plan, when it comes, will have to be in line with local plan, but I'm not quite sure why the boundary can't be included. I mean, obviously they can't come up with anything that contravenes our local plan, but interfering with the parish boundary seems, I don't understand that.
Well, the letter we sent in May to the planners essentially said what I've reported, that we would want the Manydown land to be excluded from the neighbourhood plan boundary. It made no reference from interfering with the parish boundary.
Thank you, Councillor and Mrs Taylor. Councillor Parker, I rudely interrupted you. Did you have another question for the officer? Please continue.
Thank you, Chair. I wanted just then to ask the officer, there's reference to the development period being changed from 2019 20 to 2028-29 to provide extra flexibility, and I just wanted perhaps if the officer would give us a little bit more detailed explanation how those changes achieve that, or are hoped to achieve flexibility.
In any development of this size over a 10 to 12 year period, there will inevitably be peaks and troughs in the economy, and therefore we recommend that the local planning authority, the planners, introduce a bit more flexibility in their dates to enable us to be able to develop within those peaks and troughs. So what I was talking about earlier in terms of 3,000 homes over a 10 to 12 year period, with the requirement of 11 at peak development sites, obviously is dependent on the ability of the economy to be able to absorb those levels of housing at those different time periods. And there will be some years where they'll be able to absorb more, and some years where the economy may not be able to absorb as many. So the figures I was referring to are an average, but the reason for the change of dates is to enable some flexibility to deal with those peaks and troughs over that length of period, and for this size of development.
The change of date surely just bringing it forward from 2019 to 20. The end dates don't change, so we're bringing it forward from 2019. Yes, I'm reading it wrong. Developer of this site will deliver homes and infrastructure in the period 2019-20 to 28-29.
Yeah, we're obviously not changing the end date because the plan period runs up to 2029. We're asking for flexibility about the start date to give us the potential, were the planning application to have been obtained and were the economy to be in a decent place to start earlier, given the inevitability of some peaks and troughs during that period, so that we can actually evidence the ability to deliver that amount of houses over that period of time.
Yes, thank you for that. I appreciate that. Thank you very much. Then can I just make reference to, in the report, on pages, particularly on pages 13 and 14, where we have, under several of the clauses, referring particularly to clause H, landscaping sensitivities, I, ecology, and R, sustainability. References made here, this is actually the officer advices, whilst previously it was seemed relevant by somebody to incorporate within the Manydown policy, SS 310, these particular clauses appertaining to these issues. The recommendation is to delete the clause saying as it's best dealt with by policy EM1 during master planning, ecology, and rely on policy M4, and on sustainability. It talks about possibly policy EM8. And in fact, if you go to S as well, limit noise impact, again it says delete the clause, so it's deleting that in its entirety specifically to the development of Manydown, and again rely on policy M12. My question to the officer is there the same protection afforded to this site by removing those reference to those particular clauses and then relying on general policies?
Our assessment is that there is. When we bring forward the planning application would need to be assessed by the local planning authority in the context of the overall local plan, which would include the clauses that some of those, or if not more of those clauses that you're referring to there. And therefore our assessment is that there is adequate protection. However, that's our view as a landowner, and it would be important for the planning authority to have a view, hence the reason we're raising these points, so that the planning authority can take account of them in due process through the consultation period when they consider our comments. So it's a comment from us as landowner to a planning authority, for the planning authority to then take account of in their consideration of the written representations that everyone's made when they look at the local plan after the end of the consultation period.
Another councillor waiting to ask questions. Are you nearly finished? Or do you have a list, a shopping list? Okay, thank you, Kat.
I would wish to, at some stage, discuss the pink papers, and so I'm now ending my questioning, but I would want the opportunity to question officers, or at least ensure that there is a discussion in relation to the pink papers before this committee reaches a conclusion or any decisions.
Noted, thank you. Councillor Keating.
Thank you, Chair. Can I take you to page 12 of 35, item G? The officer's report starts by saying boundaries should be evidenced by master planning. Your opinion that the revised boundary which was imposed on the 25th of July was evidenced by master planning. Thank you.
The context for that point is that when actually devising a site policy boundary, that has got to have reference to master planning evidence, and the emerging master planning evidence that we have been receiving during the course of the last few months from both Beyond Green and URS has indicated, as we've set out in this report and I've explained tonight, that the wider boundary is what is required in order for the Manydown site to be deliverable in the local plan period, and that was the essence of a letter that was sent to the planners in June.
The question relates to when the boundary was changed. It was changed in a period from Sunday to Thursday in the week concluding the 25th of July from our point of view. Were you aware of any master planning evidence which underpinned the proposed or the actual change?
Yes.
Sorry, perhaps you could elaborate.
During the period you referred to, I received an initial draft of the proposed changes, both in terms of the boundary and the policy. And on the Monday, compiled an email that was evidenced by our information from our emerging master plan to effectively identify the areas of concern, both in terms of boundary and policy at that stage.
I have no doubt that you quite legitimately responded to the proposals put forward by Councillor Riffel as a cabinet member, but did he provide you with any master planning evidence that would support his new line?
There was no such opportunity for dialogue. This was a process that was effectively being led by the planners rather than the landowners, and therefore it wasn't appropriate for either Councillor Raffel to have that dialogue with us, or for us to have that dialogue with Councillor Raffel. So at that point in time, it was appropriate that the planning side of the Borough Council came to a view around the local plan to be debated and agreed at Cabinet and full Council, thereafter to go out of consultation. And now this is the appropriate time for landowners and other affected parties to be able to submit their views. And so I have no understanding about what basis Councillor Raffel came to or used in terms of those changes, but I did obviously analyse those changes at the time that they were circulated.
Thank you. I'm obviously picking up that the original proposals were founded on substantive material evidence to support how it should be developed and when, etc., and what it should be produced. What I'm picking up from you, even though you're obviously reluctant to answer the question, did you see any planning master evidence to support the new line? I'm picking up from you that you haven't seen it. Would that be accurate?
What is absolutely accurate is that the original proposals put forward by the planners reflected the communication we had with the planners prior to the Cabinet meeting on the 22nd, and therefore properly evidenced the emerging master planning and visioning information that we were obtaining. I cannot comment in relation to what evidence and basis the Councillor Raffel changes were generated from. That's not my place to comment. And to be fair, in terms of what is technically accurate, it isn't necessarily his requirement or a requirement for him or the planners at that time to provide the evidence. The evidence needs to come through the local plan, and so what we have in front of us in terms of a pre-submission local plan would either have evidence or not, and it's their responsibility as planners to put forward that evidence and to compile a local plan on that basis, not landowner responsibility.
I'm going to stop you there, Councillor Keating, because I think we're straying away from Mr. Bailey's report. No, you're asking questions on completely different subjects. I think I'll just leave it for now. Councillor Tilbury has a question.
Oh, yeah, a couple of questions, Richard. I know on page 14 of 14 of 35 on the main ones there, the affordable housing policy, it refers to issues around viability. I mean, one of the issues that came up is there was talk of 30% affordable housing on Manydown due to this Three Dragons report, which was roundly trounced by people when it came to the committee. I don't know if it was this committee or another one. I can't remember which one it was now, but I'm a bit concerned that it's sort of suggesting viability, because if affordable housing isn't viable on our own land, and it isn't going to be viable anywhere, because within there we don't have to make a profit. So I'm a bit concerned that sort of bits in there. It implies that we may, if the Three Dragons report is suggesting it isn't viable on there, well, I think our attitude was, well, if it isn't viable, that's tough. That's the first question there. The second one is, I've raised this with you before, this idea of the district centre on there. I can see the logic there, and it gives the access to the roads there, but the idea of effectively creating another Overton on the edge of Newfound, between Newfound and Worthing, is, I think that's going to cause all sorts of problems. The other thing is the viability of it, because if you look at Oakley, which is sort of half a mile down the road, I mean, it's got a population of 6,000, and it struggles to support a one-stop shop, a few, a hairdresser, a few odd. I mean, Diana will know. I mean, a chemist, it can't support a lot of shops because it grew very large, and it's so close to Basingstoke that you're not going to get a lot of other shops there. And of course, if you put anything closer to Basingstoke, I think that could be more of a problem there. And we could plan the district centre there, and will anyone actually take it up? It seems an odd way of doing it. And of course, the other issue is if we don't, at some point when you go south of the railway line, will there be another district centre there, and that won't be on the road. I mean, I know, being involved with the map, I understand the thinking behind it, putting it there, but apart from anything else, the traffic problems it create on the road, I mean, everyone from Oakley and the west has got to come through this new district centre, and and certainly while you're building it, that's going to cause major problems. I think it's something that needs looking at, but at least it's now out in the open now, because we've been aware of this for some months now, but not really been able to tell anyone about it. But
okay, firstly, in terms of affordable housing, we at the moment don't have any evidence from the three, or any information from the Three Dragons report to come to a view, and so therefore we're reserving our position as landowners until we're able to see the Three Dragons report in relation to the issues on deliverability and viability. So we're not saying it's not deliverable or not viable. We're saying that we need to reserve our position until we've seen that evidence. In relation to the district centre, I think a couple of things it's worth just noting. The district centre wouldn't be built wholly overnight, or indeed in the first few years. It would generally develop as the community grows, and so therefore the context within which the district centre is planned is in the overall development of Manydown, not just in the first few phases or the first few years. And also the context within which it's planned is, as we're saying, is we would prefer to have a good dialogue with the planners and with the communities through the master planning stage about the notion of eventually having a district centre in that location, and about the potential constitution of that district centre. I think it's probably also important to note, as you were referencing, community centres, local centres, district centres have changed over the years, and they will no doubt change in the future years. And so our kind of approach to this is that we would want to be flexible around what is important for Manydown and the surrounding communities over the course of a number of years, rather than being rigid in terms of our thinking as a theoretical district centre. We want to actually be capable of actually referencing it both for Manydown and the existing communities through proper dialogue and proper research over a long period of time, rather than it just appearing as a particular development.
So Mrs. Taylor.
Thank you. Could I just comment about your desire to do away with the strategic gap between Basingstoke and Oakley? I'd just like to say, and I'm sure everyone must appreciate this, it's one of the key comforts for people who live in the villages just to the west that we do have this strategic gap policy, and it's something that we've brought in that all of the villages around are very, very grateful to have. And you say that the landowners do, however, recognise that an appropriate gap between Oakley and Basingstoke to prevent coalescence should be maintained. I wonder if we could just, would you mind just showing on the overhead that picture that was given? Yes, that one. I'd just like to point out, and I'm sure you must realise this because you visit, but where you can see the D of Newfound, that is the last house in Newfound underneath that D. And so if you look at the tiny little distance between that and the proposed boundary, that is effectively coalescence. And so it makes a mockery of anything approaching any sort of usable gap at all between Oakley and Newfound and this new development. And while we're on the subject of it being sound, once again, I'm sure you've read this as well, but this is the comment that was made by the planning inspector. I'm particularly concerned about that field just north of the B3400, which slopes downwards to the west, as you will know. The planning inspection 2005 said of this field, housing is proposed on the western slopes of this ridge. This land is beyond the existing visual setting of Basingstoke, and housing on these western slopes will be prominent when approaching along the B3400 from Oakley, greatly reducing the perceived gap between Oakley and the beginning of the built-up area of Basingstoke. The character and integrity of the narrow belt of countryside between them will be undermined by developments so prominent and extensive. Now, have we got any reason to suppose that any planning inspector in 2013 might say different from that?
The important thing to note is that, as I talked about before in relation to the master planning process, and the appropriate time that we discuss the issues around the boundaries and green landscaping and green infrastructure would be the time to discuss that level of detail would be through that master planning process, which would involve the community. At that point, we would obviously be wanting to explore what the art of the possible was around the whole of the development, not just the areas that you've highlighted. Obviously, during that exercise, during that master planning exercise involving the community, we would obviously gather information, views, have some technical information as well, that would then we would then use as a basis to be able to put forward a planning application to the inspector who would judge the Manydown planning application. And that is the appropriate point that the inspector would judge this particular issue, because at that point he or she would be able to understand what mitigation measures we were putting forward as a level of detail. At the moment, we are just in the process of going through a sort of comments on the local plan. The local plan inspector is being asked to judge on the deliverability and the viability of Manydown within the context of the local plan. He or she is not being asked to judge specific applications or specific details surrounding a planning application for Manydown. That's for a later stage, following consultation and due master planning process.
Last one, thank you very much. I'm slightly alarmed by the wording on section A of 3.8.10. The suggested changes. Now, in all of your presentation, you've been talking about approximately 3,000 houses, which is what we've all understood. But you want the wording to be changed so that it says at least 3,080 houses. Now, this, yes, I'm sure there is a good reason, but I'm sure it's going to be a wonderful reason. But I'd just like to point out at this stage that every house that's built, there are financial implications, are there not? So we have to, as landowners, declare an interest here in any submission that you make. Every house that's built is money in the bank for the landowners and for the Manydown company. So when you have this kind of open-ended thing, there is a clear financial implication here that has to be declared when you make your submission to the local plan.
We are declaring that in the way that we're putting the representations together, of which we declared it in the paper effectively, in terms of the financial implication. It's a technical reason. Under the NPPF, the inspector has to look at minimums, and therefore the words "at least" are consistent with the minimum requirement the inspector has to view when they consider the local plan in the context of the NPPF guidance. So it's a technical point.
Can we not, for the sake of our plan, have a maximum as well? Because obviously, it's just having a minimum is dreadful. Oh, I'm sorry.
No, the absolute guidance on this is minimum. And that's the way the planning guidance is constructed.
Right. Thank you. We're moving on to planning issues there, which is nothing to do with this committee. We've had an indication from the council that we want to discuss or to ask a question on a pink paper, so I propose that we move this into a private session. So I move that pursuant to section 100A4 of the Local Government Act 1972, the public be excluded from the remainder of the meeting on the ground that the public interest in maintaining the exemption outweighs the public interest in disclosing it, and therefore that exempt information is likely to be disclosed as defined in paragraphs 3 and 5 of Schedule 12A of the Act. Is that seconded? Thank you. Yes.